but we finish on time this afternoon. Thank you for your patience.
So I'm going to be a panelist on this one and then switch to moderating because there's two panels on just transition. So they switched the format around. So that should be okay. Oh, sorry. I'm not sure, to be honest. I can ask my colleagues who support the meeting, but I think you can also. Pictures. No, I mean, there's a live stream. Pictures are in calls if we can take some pictures. I think we're fine to start and it should be. If it's just take it. Easy. I think so. Joins go by lunch. It is. I wasn't expecting to start time, I guess.
No, let me check where she responded. Okay, well, she didn't give me a clue. All right, thank you for your patience. Good afternoon again. My name is Sebastian Deck. I'm with the Center for International Environmental Law. I've been asked to moderate this panel, during which we are going to discuss now the role of regional human rights mechanisms in ensuring a just and equitable transition to sustainable economies and societies. And I'm very delighted to be joined, or soon to be joined, by four very knowledgeable experts on the topic. There's been much discussed already in relation to just transition and related human rights obligations, and we are very much looking forward to discussing at this particular meeting the role of different human rights institutions, in particular national human rights institutions, but also sub-regional and regional human rights institutions. Before we open the panel, I would really like to encourage all of you who are here with us today to really think about specific recommendations that you could propose or specific questions you'd like to bring during the discussion afterwards, so that we can make sure that those are captured in our discussion, but also that they can inform the report that the Office of the High Commissioner for Human Rights is drafting of this particular workshop. As we have heard this morning, this topic could not be more timely. During the discussion at both of the morning sessions, we already heard some of the participants stress the importance to ensure that environmental policies and the need to respond to the urgency of taking climate action and other actions on environmental threats is not used as an excuse to create new threats and new harms for vulnerable communities. But this transition to a fossil-free world is not weaponized against specific communities. And so I think I'm very interested now to further this discussion and to actually hear from different panelists and from you here to what extent the different institutions that are here with us today can actually really contribute to better understanding what are the legal standards in terms of states' obligation in the context of just transition. How can we help advance this principle, this concept, while making sure that it remains anchored on human rights obligations? And so this is going to be the focus of our conversation. We'll have 4 panelists, as you know, coming with brief interventions, reflecting in particular the perspective and the lessons learned also from their particular institution, and perhaps also sharing some key highlights from recent reports that have been written on the issue. And then we hope to engage in a rich discussion with you. Without further remarks, I will just give the floor to Elisa Margera. I will just introduce some of the panelists very briefly because you already heard them before, but for anyone who is joining us specifically for this session, Elisa Margera, of course, is the current special rapporteur on climate change and human rights, and she is also a professor of international and sustainability at the Durham University and at the University of Eastern Finland. Elisa, I know that you've been doing a lot of work specifically also on the relevance of human rights norms in the context of a just transition, and this has been already the focus of some of your work. And so given who is with us here in the room today and the focus of this particular workshop, I'd be very interested to hear from you what specific role do you see regional and other human rights institutions being able to play as we move towards a just transition and the defossilization of our economy is grounded on human rights. And I would note that your latest report was exactly on the importance to move beyond fossil fuel.
Yeah, thank you so much, Seb, and apologies, colleagues, for joining a little bit late. The human right to a healthy environment has really been the core upon which I have developed the work on the mandate in relation to the just transition for 2 aspects. First, I think the importance of the interrelations and interdependencies of the substantive elements of the right and how that chimes with the most recent science on the nexus between climate, nature, water, food, and health. And how important it is to see human rights, and in particular the human right to a healthy environment, not only as a legal standard, but also as a lens, an analytical lens to understand where we're falling short, maybe in areas of law and practice that have not been as in contact with international human rights law as others, and to really see that, kind of challenge that idea, the human rights, compliance with human rights, it's not asking states who are trying to address climate change, to address biodiversity loss, to address economic inequalities, to do something on top of their objective. But that in fact, engaging with human rights is helping states to see more clearly what are priority actions and more effective means of implementing their other policy objectives, including that of climate change mitigation and adaptation, and also broader environmental objectives. And in particular, I've also placed an emphasis on the role of children's environmental children's right to a healthy environment and the principles of the Convention on the Rights of the Child, including giving priority to children's best interest, again, both as a matter of clarity of international law, but also, again, as a lens that helps to address some of the well-known shortcomings in decision-making that eventually harms the environment and human rights, which is short-termism. And so really taking the perspective, particularly of children's rights to development, of course, how their vulnerabilities to environmental harm evolve and how different developmental windows across their young lives gives us a sense and a very clear evidence in science, medical science related to children's health, to give us a very specific understanding of how decisions today may affect children and other human beings 5 years down the line, 10 years down the line. And these are all existing obligations applicable today, and as I said, for which we have very meaningful scientific evidence to rely upon and understand the full range of considerations that should be taken into account when we're looking at environmental decision making, and in particular, our transition towards a safer climate. The other element of this is, of course, the procedural dimensions of the human right to a healthy environment. We've already discussed this morning. And maybe I just want to reiterate a key point, which is that inclusive processes where authorities are really listening to the lived experiences of the most affected human rights holders, most affected by climate change, most affected by multiple grounds of discrimination and vulnerability, the insights from environmental human rights defenders. This is also core evidence. It's the human rights evidence that allows authorities to really think through the implications of their decisions, making sure we don't repeat foreseeable, predictable mistakes that we have made time and again in our development processes. But even more importantly, and this leads me to my third point, through that understanding of lived experiences of those that are most affected, we also have the deeper understanding of the systemic causes of the planetary crisis we're facing, and that attention, that focus on the state action and changes in business conduct that are really the most effective in changing course and allowing us towards a path towards a safer climate. And that's about understanding power imbalances, legacies of colonialism, repeated patterns of extractivism. And what's interesting for me there, that these are maybe familiar topics for human rights experts. They're not necessarily always so familiar, particularly by certain areas of natural sciences, which are the usual areas of science on which we depend for making decisions, including on the just transition, but are indicated now by global assessments of the science on transformative change, which is what we know we need as opposed to incremental change to really protect humanity from the planetary crisis. And that shows the link, inextricable link between meaningful environmental action and addressing the root causes of economic inequality. And that's where we arrive on defossilization. So my work then, based on these premises, in my recent report to the Human Rights Council, was looking at the human rights obligations applicable already to the question of fossil fuels, but equally all the areas of science, including climate science, but also expanding to biodiversity science and health science, which are indicating how today every state has an obligation to phase out fossil fuels, not only because of climate change, and of course in that context we have the principle of common but differentiated responsibilities, but also for protecting our own citizens right here, right now, from the health impacts that affect every single organ in our body, that affects generations from the full life cycle of fossil fuels, from exploration to exploitation, transportation, processing, all the way to waste management. And all those activities beyond fossil fuels being the main cause of climate change also cause a whole other series of environmental harm to our food system, to our water resources, to our own bodies, that not only undermine even more the capacity of nature to regulate the climate, but also significantly undermine human resilience to climate change while facing increasing and more unpredictable impacts of climate change. And so the conclusion and the key point in that report was saying not only we have existing human rights obligations that support the phase out of fossil fuels for all states with certain differentiated approaches to timelines, and of course important, crucial obligations of international cooperation in terms of finance and technology. But we have also obligations to defossilize our economies, looking at the health sector, the agricultural sector, looking at the production of plastics and petrochemicals, which are intrinsically linked to what we're seeing as an expansion of fossil fuels and are basically sacrificing today's generations and next generations' well-being in ways that are compounding climate impacts, as well as keeping us locked into a climate crisis. And maybe the final point is that while it is a difficult process to imagine even what our lives and economies may look like without that dependency on fossil fuels, it's also this opportunity to reclaim space for thinking about what we want our societies and economies to be like, and fully support human well-being, planetary well-being, with all the science, including indigenous science and local community science, that is available to us, and it can allow us to take decisions that are truly at the nexus of climate, nature, water, food, and health. Thank you.
Thank you so much, Elisa, and I would really recommend anyone to read the latest report that addresses this issue. I'm very glad that you concluded on this hopeful note, really highlighting the fact that actually our experience with human rights institutions and human rights norms can help us reclaim the transition as an opportunity and not only as a threat, as we discussed this morning. And you mentioned in particular the importance, if I can highlight some of the key points, but then I would be interested to build upon the role of human rights institutions in helping us build upon existing human rights norms, channel and consider lived experiences of the communities affected, and then also having this experience in addressing systemic issues that are underpinning inequalities and human rights threats. And so now with this, we can actually turn to some of the regional and national human rights institutions. First, we'll start at the regional level. And we will be very interested to hear what is your perspective in the role that your institutions can play. So first, I'll turn to Dr. Thea Yalashvili, who is the first Deputy Director of the OHCHR, Office for Democratic Institutions and Human Rights, with a very broad, extensive experience in strategic policy development, management, and administration of technical cooperation programs. And I'll be very interested to hear from your experience, what is the role of regional institutions in addressing those different opportunities that Elisa mentioned?
Thank you. And I will try, of course, to move a little bit from this very academic and important discussion to a little bit more technical, aspects of the work. And Your Excellencies, of course, it's indeed a great pleasure to continue contribution to this very extensive discussions that we're having for the last 2 days, and I think very timely and important ones. And I think that when we're talking about the just transition as such, it's not it's a very wide concept. So then the bottom line here is that we should not leave anyone behind. So I think that when we look at these concepts from that perspective, then a lot of frameworks arise and a lot of potential comes in order to work together and address those issues. First and most, I think that the primary objective, if we look at this just transition, has to be that, really the anti-discrimination and the gender equality aspects has to underpin, because these are the two main primary pillars upon which the whole edifice, when we're talking about the human rights and fundamental freedoms protection, rests upon. So in that sense, I think that we need to look into those aspects. Second, as you rightly mentioned already, in the beginning, how important it is to institute the proper legislative frameworks in order to be able to look into the issues and to be able that the citizens have a right access, to those, legal aspects that are of crucial importance. But I think everyone would agree that only legislation would not play an important role if we don't have the mechanisms of its implementation. And therefore, when it comes to the implementation, the institutional frameworks comes into the play, where, of course, it can be the national, it can be the regional, it can be, a different and various actors, at the state level and at the international level. But at the end, we should to have efficient mechanisms that would provide the proper redress opportunities when it comes to the just transitional matters. Third issue, I think that then it is also always related to, and sorry, I need to speak slowly. I know I was told to speak slowly. And the third issue, I think that it's extremely important that we have this academic discourse about it and being able to have the qualitative and quantitative data in order to be able to have this very informed decision-making policies in place, because without this proper assessment and without this discourse, it becomes very complicated and difficult to do so. And last but not least, I think that what is also of crucial importance, how we energize, how we engage, and how we advance the civic space, because this is exactly the mere factor that how the non-state actors play an important role in this, and also not least important, how we support the civil organizations in order to be able to advocate and promote those important rights. From that perspective, I mean, allow me to list a very few specific, I mean, issues that we do and we see that it's extremely important, which might not be, you know, I mean, from the outset seen kind of like as a direct, I mean, addressing of the issues, but which we truly believe has an important role. And one of the most important things is the monitoring activities, how we monitor this and how we monitor the freedom, for example, of association and assembly when we are talking about the protection of the rights. So how those who are those human rights defenders or the citizens who would like to claim and work on these aspects are able to exercise their right to freedom of assembly and freedom of association is one of the very important tools when it comes to the monitoring activities. Second issue where we're talking about is gender mainstreaming and gender aspects in that sense, I think a slightly different but very important angle is that how we advance and empower, in particular, women political decision making in this process at the various levels, and how we make sure that those voices are heard, because we know that these issues, I mean, sometimes has an impact, I mean, on a different genders from a different perspectives, and how we understand and being able to make sure that women really promote and protect those ideas. So, and last but not least, of course, I mean, I would never get tired, I mean, of mentioning of the civic space, and of course in our platform and in our frameworks, we have the so-called human dimension implementation meetings where there is a given an opportunity to the wider civil society representation and participation hand in hand with the governmental actors, where the issues that are so pressing and important for the broader general protection of human rights and fundamental freedoms are taken here. And last but not least, of course, because it can be a non-exhaustive list, that the work that, of course, I mean, our second dimension component of the institution as such, where we'll look into the economic and environmental aspects and how best to also coordinate and cooperate with the participating states in order to being able to, on one hand, to monitor, and on the other hand, to support instituting such a mechanism that will be capable, efficient, and effective to address the issues. So it's a very nutshell, but I, of course, remain at your disposal to answer any related questions. Thank you.
Thank you so much. And I'm very glad that you took us from the concepts and the theory into how technically, how practically actually existing institutions can help, in particular because they already are embedded within the institutional framework. And so in relation to, for instance, the focus on monitoring, one thing that we have heard again when we discuss just transition is the unprecedented scale of this transition that will be required. And so the importance of retaining this as an iterative process where we can monitor systematically and integrate the voices of those that are impacted and take any corrective measure along the way, respecting, of course, existing national or international legislative framework. And maybe now to take one step further into even more embedment within the institutional framework, I'll be very happy to turn to Mr. Khalid Ramli, who is the Director of Cooperation and International Relations at the National Human Rights Council of Morocco, CNDH, and is a National Human Rights Institution Fellow at the Office of the High Commissioner for Human Rights. And we will be able to hear from the perspective of NHRIs, what is your experience in terms of contributing to national decision-making in relation to the just transition? And also what I would be very interested to hear, Mr. Ramli, is your expectation in terms of cooperation between national human rights institutions and the regional bodies that we have been focusing on over the last couple of days. And I'm very grateful for your presence because we know that the the National Human Rights Council of Morocco has really played a key role in actually considering the relevance of human rights norm at the national level in the context of climate change. So thank you for this work.
Thank you very much, Chairperson. It's my pleasure to participate in this event of great importance, and I would like to thank colleagues from OHCHR, especially NERMS, for inviting the National Human Rights Council of Morocco to take part in this event. And I'm going to share with you, I'm going to try to respond to your expectations regarding some key points and examples how NHRIs can engage with regional human rights mechanisms to ensure a just transition to sustainable economies and societies. First of all, as you may know, NHRIs and regional mechanisms complete each other in terms of mandates. They constitute allies which can play mutually reinforcing roles regarding environmental rights and ensure that environmental transitions are just, non-discriminatory, and likely to bring adequate responses to human rights impacts. They can also work together to highlight the reality that many countries of the global south are disproportionately affected by the consequences of global warming, despite being the least responsible in terms of house gas emissions. And both NHRIs and regional mechanisms can work to urge states to ensure compliance of national legislation on environment with the international human rights standards. Not only binding instruments such as the Paris Agreement, but also the instruments that fall under the soft law, particularly the most recent resolutions that have been adopted by the Human Rights Council and the General Assembly. For example, the CNDH of Morocco, in line with this mandate, recommended legislation that ensures that not everyone in Morocco benefit from social security, mainly the most vulnerable groups, especially during periods of job losses linked to ecologic and economic transitions. The other point that I would like to highlight also, the multi-stakeholder partnership. It's very important, and it's a key avenue for achieving positive impact. And civil society in this regard should be part and parcel of this partnership because they are uniquely placed to understand realities on the ground and can contribute bottom-up information to ensure that local concerns and recommendations are adequately taken into account. In our local consultations, for example, especially with children, we ensured that the voice of NGOs from the 12 regions of Morocco is heard to address their rights, the rights of children, including climate justice. The engagement with the parliament is also very important, and you know that the parliament is the legislator, and we need, as NHRIs, ensure that laws include human rights approaches to environment and reflect recommendations coming from both regional and international arrangements and mechanisms. And this is a key role of NHRIs. In Morocco, for example, we have a formalized partnership with the parliament through a memorandum of understanding where we can bring about advisory opinions and memorandums on draft laws. I would like also to share with you one experience in Morocco that recently we submitted, for example, a memorandum on the right to water. And we recommended that the management of water in the context of an increasing scarcity in Morocco, we have been suffering from water stresses and water crisis due to consecutive years of droughts in the country. And we have made this memorandum and we submitted to the parliament and to the government, and we told them that this should be taken into consideration in the policies and the legislations, with the focus, of course, on the rationalization of the use of water to ensure the most vulnerable, especially in rural areas, mainly small farmers. Regional mechanisms also are invited to join the efforts of NHRI through the Global Alliance of National Human Rights Institutions. You know that we do have an umbrella, which is GANRI, the Global Alliance, and we do have a strategy that includes environmental on climate justice in this strategy. We have been engaged with the Special Rapporteur on environment in this regard, and it is also an invitation for regional mechanisms to engage with GANRI regarding this issue. Also, in terms of research and analysis of regarding the policies in force, we propose solutions on how to fight against poverty likely to be caused by just transitions. And in Morocco, we identified several projects underway with a social and economic nature. These include, for example, desalination stations and pipelines between water basins, and these are supposed to improve the economic conditions mainly for the most or for the communities at risk of droughts. Also, NHRIs have a key role in proposing and leading processes of general national plans or national action plans on business and human rights. There are several examples I can show. For example, in Africa, we do have like 4 national action plans on business and human rights. The most recent was in Nigeria, and the NHRI played a key role in leading the negotiations and the dialogue resulting in a NAP, or a national action plan in the country. So in this national human rights institutions, regional mechanism should engage with the state, because at the end of the day, policies is the responsibility of states, and climate justice, just transitions should be prioritized in those plans. Capacity building is also very important. It has been mentioned several times by different panelists this morning and today, and including for the rising generations. And this is what we have done in Morocco. We targeted a group of young people and young human rights defenders. We worked with them on the right to healthy and clean environment, because this is very important and it is an emerging issue. We noticed that most of NGOs in the country are mainly focused on the classical rights, civil, political rights, economic and social rights, women's rights, but this issue, or we consider it an emerging issue, environmental right is also mainstream in the strategy of our institution. Regarding case management, it's also important. We know that both regional mechanisms and national human rights institutions, they play a quasi-jurisdictional role in terms of complaint handling. So we did this, and we have experience, and we do have examples of a group of civil society organizations coming to our NHRIs, and we engage with the authorities with a view to resolve a case regarding the establishment of a plant for the management of garbages of the new generations. And we did the research, we did the monitoring, and we did also the investigation, the dialogue with the authorities, and we noticed that this project could have effects and impacts on economic and social rights for the local communities. Fortunately, this project has been withdrawn and suspended. Well, there are other cases. I know that I went beyond the time allocated to me. Independent reporting is also very important, because NHRIs can report to regional mechanisms, but also can report to state institutions, and they should include this. This is what is required. We include, and of course, this required also from regional mechanisms with experience to build the capacities and to reinforce the capacities of national human rights institutions. The organization of mega events is also very important. In Morocco, we are going to organize the World Cup together with Spain and Portugal. And in this regard, I have to mention that we conducted an analysis study requested by the FIFA, the International Federation for the Football. It is submitted, it is available on the website of the FIFA. It was an win. And environmental rights is a focus area in this study, and there is now a strategy with commitment from the government to ensure just transition. We did this as a national human rights institution, and this is very important. And we believe that sports and human rights should be also systematically incorporated in the work of regional mechanisms. I have several other examples, but I can share with colleagues here at NERMS my presentations. But finally, I would like just to mention that let's not forget the opportunities offered by artificial intelligence. And we know that this can also prevent human rights impacts caused by transitions. And of course, this requires, as I said, further capacity buildings for all stakeholders, NHRIs, civil society, all those who are involved to ensure that early, for example, warning systems are in place to guarantee just transition. Sorry for being a bit late, and I'm at your disposal for any questions. Thank you.
Thank you so much. And there is no need for apologies. You covered actually the full range of tools at the disposal of NHRIs in order to intervene and contribute to anchoring human rights norms in a just transition, whether it's engaging with existing branches of the government, working on business and human rights and the National Action Plan, the role of NHRIs in capacity building, but also conducting human rights assessments, reporting, and the quasi-judicial role. So I feel we could hear a lot about the very practical experience of the National Council of Human Rights of Morocco. And I will be very eager to hear more from the other examples that you were willing to bring to us. But maybe before we come back to this, I'll now turn to Benjamin Schachter, who is with the Office of the High Commissioner for Human Rights. Ben has been coordinating the work of the office in relation to environment and climate change, and is going to be well positioned to share with us maybe some of the highlights from a very recent or a recently published report by the UN Secretary General on opportunities, best practices, solutions, challenges, and barriers related to a just transition and the full realization of human rights. So Ben, I'd be very eager to hear what are the key lessons that you drew from this particular report, and maybe also based on all of the experience that was collected to underpin the content of the report. Again, where do you see regional bodies actually being able to really contribute, not academically, but from very practical perspective?
Thank you very much, and pleasure to be here with all of you. We've got a really thorough discussion of just transition that's already taken place and will continue into the next panel. What I want to do is speak a bit towards the Secretary General's report that Sebastian referenced, and also just share a sort of few reflections and thoughts related to the broader work of the office on human rights and just transition. And indeed, I think just the question of what a just transition actually is, right? And that was the starting point for us when we started working in this area, and the office developed jointly with ILO a set of key messages on human rights and just transition several years ago, and I would encourage you all to refer to those because they reflect a real collaboration between ourselves and the International Labour Organization in this area. But when we got the mandate from Human Rights Council Resolution 56/8 to continue working in this area, it was quite exciting because everybody's talking about it, but nobody's quite sure what it is. And there are very different views and perceptions about what indeed a just transition is. And we want to make sure that it's understood as a transition with human rights at its center, a transition that's not just about transitioning away from fossil fuels, but actually about the broader changes that we need to see in order to move from our current paradigm of unsustainable consumption and production of environmental crises to a new paradigm of sustainable economies and societies, right? So when we talk about just transition, we're talking about that just transition anchored in human rights to sustainable economies and societies. And of course, fossil fuels are a huge part of that.
And I also want to refer to, you know, we're going to hear later from Javier on the Inter-American system, but we have the recent advisory opinions of the Inter-American Court and the International Court of Justice that talk about transition, talk about just transition, talk about things like the need to apply precaution as well when thinking about the technologies that are going to help support this transition. And there's that whole spectrum of issues, right? If we're moving away from something towards something else, we have to make sure that that something else is actually better. So the Secretary General, in addition to the report, which I'll come to in a moment, has convened a panel on critical energy transition minerals. And the very first principle of that panel, in its report, it contains a set of principles about what should guide what should guide the approach to critical energy transition minerals. The very first principle is human rights. And so that moving away from something has to be moving towards something better, right? I think is the starting point. The resolution did indeed ask us to look at barriers and challenges, and we identified a number of those, including continued fossil fuel dependency, conflicts over natural resources, inadequate labor rights and social protection, insufficient economic metrics. So the need to go sort of beyond GDP, which is another key focus of the UN system, business accountability, addressing compounding inequalities, erosion of the social contract, an inequitable distribution of resources and technology. So again, I think from that sort of quick synopsis of those key barriers and challenges, you can get the sense that we're really talking about systems change. We're talking about the transformative change that's needed. The Kunming Montreal Global Biodiversity Framework refers to living in harmony with nature, right? I mean, we couldn't be as a collective, we couldn't be much further from that than we are. And there are certainly people and peoples that are doing better than others, but human society as a whole has a long way to go to achieving those objectives. So the four key recommendations that come out of the SG's report, or pathways towards sustainable transition, are transitioning towards sustainable human rights economies. This starts with building economies that prioritize planetary and human well-being, and the realization of all human rights, including in particular people in affected communities and the rights of indigenous peoples. I already mentioned going beyond GDP. We need to change the way we measure success. Equitably phasing out fossil fuels, while ensuring affordable and sustainable energy for all, establishing business accountability frameworks that cover transnational value chains. So that we all kind of fit into this idea of rethinking our economies. The other pathway related to ensuring decent work, a second, universal social security and social rights for all. A third, focusing on strengthening rights-based and participatory governance, ensuring participation, integrating human rights obligations throughout just transition-related laws and policies. You see some language on the sort of specific kinds of actions that need to be taken in the Inter-American Court advisory opinion, for example. And then finally, enabling globally just transitions through international cooperation. And I think the ICJ advisory opinion is very clear on the obligation to cooperate to address this crisis, and the fact that that cooperation needs to be guided by the principles of common but differentiated responsibilities. And so thinking about how to increase grant-based just transition finance, how to make sure that debt restructuring and other things happen in a way that allows all of us to move forward together. And before I close, I'm past time, of course. Sorry for that. But I would also point to the very end of that OHCHR advisory opinion, where they admittedly say we're not really talking about the law anymore. We're talking about what has to be done, that we are all facing an existential crisis. We all need to work together to address it. And I'm paraphrasing, which I shouldn't do because I'm a lawyer, but but that's the sentiment of the International Court of Justice looking at this problem. It's so huge. We all have to come together and work towards achieving that just transition. So I'll stop there. Thank you.
Thank you. And thank you for bringing us to this very powerful conclusion of the advisory opinion of the International Court of Justice. If you haven't read the advisory opinion in full, I really recommend to read those final paragraphs that reminds us basically that, yes, we have a transition that is unprecedented, that we need to embrace, but we also have a legal norms that can help us there. And it's just a matter of making sure that we embrace this transition based on those norms and those legal standards. I'll now thank all of the panelists for their very rich contributions and turn to all of you participants or to the panelists if you have questions also for one another. I'd be very curious to hear also from other people in this room, building on your very rich experience and your institutional knowledge. If you have any additional contribution in relation to the importance and modalities for us to center just transition on human rights norms, and in particular also what is the role of regional, sub-regional human rights bodies, whether they are there to monitor or to adjudicate human rights disputes.
I think that everyone is getting close, tired. But no, I was interested whether in this audience, colleagues are aware of any very extensive scientific discourse when it comes to the just transition related matters, and whether there is any kind of like a work carried on this, how to ensure these economies. I mean, so maybe some examples that the colleagues can give, because lately I'm very much interested in a very kind of like a comprehensive assessment of the situations, which of course I mean monitoring and the assessments will not be, but rather than more in-depth and rich scientific, I don't know, discourse about the issue. So maybe, thank you.
Would anyone like to respond on the importance of a knowledge base to a just transition? And the special rapporteur on human rights and the environment also emphasized the importance when we discuss knowledge to embrace both scientific and non-Western sources of knowledge. So I'd like to bring this point back here. I wonder, Ben, you've been following in particular the negotiation of the Intergovernmental Panel on Climate Change. So maybe there is something from your experience, but I see Sandra from the International Commission of Jurists.
Thank you so much. And I don't want to say too much because I'm on the panel after, so I don't want to disclose all my points. But just prompted by this specific question, and of course, I'm not talking about natural science now, but maybe Ben would have talked about it. But in the area of economy, at the OHCHR, it's nothing new, and we have this. I don't know how many people in the room know of the Surge initiative, but all the work of actually economists who are working with human rights lawyers and are working with the OHCHR to define and implement in a very real way what does it mean to have a human rights economy, right? And for many things, it's nothing completely new. We have been talking about that in many ways for decades, but now there is a really big push I guess, prompted and by the necessity of addressing the triple planetary crisis as an urgent matter, to include all the climate and environmental dimension very explicitly in this work. But we have economists who are working directly hand in hand with national human rights institutions, but with human rights lawyers, etc., to make this happen. So just wanted to flag this particular initiative, and I'm sure there are many, many more. Thank you.
Thank you.
Can I go after?
Okay. No, thanks for the question or comment related to science. I mean, the place where we like to start is there is a human right to benefit from scientific progress and its applications. And it's not really talked about enough and frankly, I think applied or understood well enough. And so when thinking about science in the context of, let's say, the climate crisis or multiple planetary crises, we can think about the work of the IPCC. OHCHR has actively engaged in those negotiations. It's interesting that it's both a scientific work and an intergovernmentally negotiated outcome with scientists involved in the process. Mm-hmm. The result is an output which has, both a sort of international buy-in, but reflects a consensus and the full body of scientific knowledge related to climate change. And the sixth assessment report is very clear. We don't have a lot of time, that there are pathways still to transition, and that the safe pathways involve using the knowledge and technologies that we already have, that we know aren't going to create new or different problems, right? Mm-hmm. Because that's the thing about new technologies. They have potential benefits. They also have potential risks. And certainly when you're talking about climate change, geoengineering, including things like solar radiation modification, have a huge potential risk that just hasn't been adequately addressed. And I think it's important from that perspective that the advisory opinions talk about a precautionary approach when we're thinking about new technologies and new ways of addressing environmental crises. We really need in place a governance framework that's going to make sure those technologies aren't deployed without first understanding what the potential implications and consequences of them are. And we need to take the precautionary approach with respect to those technologies. And then there's so much that can be done by just increasing access to existing safe renewable technologies, to working with indigenous people's free, prior, and informed consent to expand and build upon and share their knowledge that can help us adapt to and respond to environmental crises. And finally, I want to say a word on businesses, because part of how we perceive and understand science is what is communicated to us through businesses, through their advertising, through their lobbying, through their participation in government delegations. And there is a real issue with not being sure that our scientific understanding of problems hasn't been influenced by a profit incentive. Mm-hmm. And so again, the ICJAO talks about the need for effective regulation. That is really critical. We need to understand that the science we're looking at is the best available science. The Paris Agreement talks about that, in independent science, that the scientists are safe, that they're not under threat for voicing their independent views. So there's just a tremendous, sorry, I went for a very long time. There's a tremendous amount of really interesting areas that we could touch upon here. But the IPCC found, as I was saying, a human rights-based approach, right? The science validates the human rights-based approach, leads to more effective and sustainable outcomes. Mm-hmm. And that I think, as a product of those both scientific analysis and an intergovernmentally negotiated outcome is quite powerful, and we really need to be implementing that kind of finding.
Thank you, Ben. And that was also a great way to build upon some of the conversation we had yesterday or this morning around the importance of curbing corporate capture and the linkages between the precautionary principle and human rights norms, and how different regional and other human rights bodies have a particular role to play in actually helping us with understanding of what are the pathways to policy making. I'll turn to Elisa to answer the same question, and then I will really invite other people in this room to think about any additional complements, or also to share your own experience within your own institutions. We're really hoping to foster this conversation. And we heard from some of you already on previous panels about the experience of ongoing future processes at your regional level, and we'll really be interested to hear more about those. But first, Elisa, on the knowledge base.
Yeah, thank you so much. I'll try and say something maybe a bit unexpected, and that might help as a bit of a coffee capsule for us to be more active after the lunch break. But where do we find that knowledge base? We might find it in a football club. We might find it at cities level. We might find it in litigation. Just this evening, I'm organizing an event which I'm quite excited about and a bit nervous about. It's about 4 examples of innovation from the bottom up. And it's about how, if you look at the element like science, the global science from climate, nature, health, it all feels very, I think, overwhelming for states, because all our relevant authorities are very separate, right? We have separate ministries that traditionally work on these issues separately. And even that idea of them integrating their work and contributing to that integrated evidence base is daunting. But from the bottom up, those things, again, come together in people's real lives and their initiatives. So I'll give you an example. So there's an Irish football club that is doing its own process of just transition. How they're doing this, it's very intergenerational. You have all ages who are brought together by football. You usually have children like training in the football club, and they have built around the football training also just transition skills training, so enabling who will not become a professional footballer to maybe have easier access to renewables and other just transition activities. But I've also been going around the neighborhood asking what are our energy needs, how we're gonna, fulfill them. They're now put together a large-scale finance for doing renewables based on this process around the football club, and they're connected to other football clubs in Europe. And you can just see how, this is a very scalable model, and it's a model where we bring together people who are already connected, have a shared passion, but also there's this effort or going and understanding what do we need to live a better life, and then build from there. Another example, it's a people's plan for adaptation. It was developed by a group of communities and social movements in Durban in South Africa, very much supported by academics with very inclusive methodologies. And very recently, this plan has now been adopted by the city of Durban. It wasn't like mandated by the city, it was something that citizens did themselves, because they were, they had been time and again by climate events and other events. They were very worried about quality of life, their own security. So they developed their own plan, and they worked out all the tensions, there were social tensions, economic tensions that were there, exclusions, and worked that out for the administration. So they were able to do maybe things that sometimes for public authorities are very difficult because of internal pressures, because maybe we're not able to pilot more participatory methodologies. Sometimes we have to invent those methodologies, and this is why the role of researchers was so important. And sometimes it's litigation, so going back to the role of the judiciary. So another case is from Mexico, so indigenous-led litigation to reclaim local budgets. So to show that parts of local budget should be allocated to those indigenous peoples to carry out their own indigenous-led just transition, because they weren't able to negotiate that directly with the public authorities. The final example is children-led litigation in Hawaii. This was in an interesting case where Hawaii already had very good legislation on just transition, very ambitious targets, and yet the public authorities were unable to implement for all sets of like lock-ins, for difficulties in really realizing this. And through the litigation, what the court what the court mandated was to say, well, we need a children council to work together with the public authority and help with the process of engagement with society to decide what are the pushbacks to this decarbonization, in particular of the transport sector. What are the things that we're not able to address? And it's been that collaboration and having children involved, having society coming together in that dialogue with, again, more novel approaches and different interlocutors than maybe the ones that are usually in that room, that has helped for significant progress. But to me also shows how can we do things differently and how we create spaces, resources for, again, imagining a different way of, for our economies and for our societies. Interesting enough, none of this had to do with defossilization, but what I'm curious to do this evening is to see what are the insights, the ideas, the inspiration, the methodologies that we can use for those really difficult conversations around moving away from fossil fuels, while ensuring that we actually expand access to energy, we address poverty, we enhance health. So this is where sometimes the evidence base comes together and where we co-develop the knowledge, and through that we co-develop the solutions.
Thank you so much. It's very refreshing to hear about those novel approaches. I wonder if anyone in the room would like to share more about other novel approaches that your institutions have been able to implement or to experience in the past. I must say, sitting here, it's very impressive to see all of your nameplates and all of the institutions reflected here. Of course, that's something we've seen over the last couple of days. And I think that's why we are very excited and eager to hear more from experiences of your institutions. We'll hear from the European Court of Human Rights. Thank you so much.
Yes, I can see that you're trying to initiate some dialogue, so I'll jump in as well in the spirit of putting comments out there to try and get us all a bit thinking. But you invited us to talk about the internal processes of our institutions, and if we could share anything about those. Obviously, the court's a bit limited about what it can say internally, but speaking of the science and all the information out there, I thought it was worth flagging up what I think is probably, evident to any readers of the Klimasenioren judgment and other recent ones on climate change and the environment, that the court has really, in the drafting exercise, gone out of its way, not gone out of its way, but has made a really big effort to put absolutely everything in there concerning the science and the current state of reporting from international bodies, from other domestic litigation. It's effectively a one-stop shop for that moment in time on reports about climate change, and the fact that it's documented in the judgment from the court's perspective means to some extent it is here, it is reliable, and we expect states to take it seriously and to act upon it. So, like I said, I think this is probably evident to readers of the judgment, but I can confirm that from inside the court, this is something that's obviously very considered and reflected on, that it's important to have really comprehensive vision on all the science that's out there on these topics. Thank you.
Thank you, Ms. Rianston-Cross. I really appreciate this example because I think that in that particular judgment, what the court does is also to lay out a little bit a blueprint for the integration of science and how it is reviewed then from the perspective of the very robust legal standards that the court is called upon to implement. So that's a great example. Thank you so much. I wonder if there's any additional examples or maybe questions for some of the panelists or other people in the room in terms of how do we ensure that human rights institutions that are already located within the institutional framework can actually contribute to further centering of human rights in the just transition.
Maybe just the debate is very interesting and very insightful. What's going on now in terms of human rights? Human rights also are under transition. because we are talking about science. In the past, we used to use, for example, classical methodologies to monitor rights, civil and political rights, economic, social rights. But now, with the advent of these emerging issues in terms of human rights, in the past, we used to recruit for example, for institutions, we recruit mainly low profiles. And now we need also those with scientific background to do the follow-up, to do the monitoring, because it's very difficult, it's very accurate, it's very concise. Imagine not only climate change, but for example, artificial intelligence, where now human rights are increasingly practiced in the digital spheres. When it comes to the right to, for example, to freedom of expression or freedom of associations, we have been noticing in different contexts the increasing role of those with scientific backgrounds. If we don't have, for example, in our institutional frameworks, whether NHRI, civil society, OHCHR, international mechanisms, or regional mechanisms, we need those people to help us understand exactly. Nobody would understand, for example, the algorithms and what it requires to do the monitoring, to do the reporting. Therefore, I would like maybe to suggest recommendations that may be included in the report of this seminar, of this event, which is we need to reflect on how we build the capacities of different stakeholders to do their jobs adequately. Because I'm coming from a national human rights institution background, and I recognize that there are gaps in terms of scientific knowledge of these issues, climate change, artificial intelligence, but also bioethics, and what, for example, the repercussions of the COVID-19. So we are not going to address these issues only with the classical tools and the classical methods. I think there is an invitation to reflect upon the tools, how we can adequately address these issues as stakeholders. So not only NHRIs, but civil society and international and regional arrangements. Thank you.
Thank you for coming back to the point of ensuring that human rights, that stakeholders and institutions can continue to perform their duties or to fully uphold human rights obligations in the context of novel technologies. I think it also echoes some of the discussion we had yesterday with Michael Wunfo from the German human rights institutions, who also mentioned some of the recent developments related to the right to science, the role of a precautionary principle, and the role of human rights institutions in that context. I'd like to ask again if there is anyone else who would like to share any additional reflections, lessons learned, or maybe also reflection on some of the challenges related to a just transition. Yes, please.
Back, but again prompted by something that was just said by our colleague from the National Council of Morocco. I guess I really agree with you that the pace of changing and like the acceleration of certain technical areas is definitely challenging, especially for legal and / judicial actors. But I guess I have a slightly different kind of historical perspective on that, because I've been working my whole career, so more than 25 years on economic, social, and cultural rights, and we have had always to deal with very technical issues, and that's why we were working with UN technical agencies, with WHO on health issues, etc. So I had to acquire, as well as a lawyer, public health elements and knowledge. I had to read technical reports on environmental impact assessment when I was working with indigenous communities on land, water, and other issues. but also on civil and political rights. I had to, at the time of my career working more on international criminal law in that relationship, I had to acquire basic knowledge of how forensic experts will work, or how to even torture. It allowed me to work with police officers and law enforcement. So just to say that I think it's not inherently different from what we normally do if we want human rights to be more than cosmetic. If we want human rights to do, that was mainly the message that all of you gave from the panelists. Like, if you want human rights to do something like a tangible change in policies and in concrete, then you need to apply them. And to apply them properly, you need to collaborate with people who have the technical knowledge, right? And I really appreciate Elisa's point on not only looking at the kind of more academic scientific knowledge, or but also the experts from people on the ground who are most of the time very innovative because they need to. And so also learning from this has always been there. But of course, again, the pace of what we need to acquire is immense. So on artificial intelligence, I completely agree with you, and some of these issues. So just wanted to give this reflection. Thank you.
No, thank you so much for bringing us back there. I think it's a very important message that we should not use the novel dimension of some of those crises as an excuse for us not to do the very diligent work in actually working with the relevant stakeholders, the relevant experts, using our human rights methodologies, building on the existing institutions and strengthening them, of course, when necessary, in order for us to continue to actually integrate fully human rights in the context of policies that maybe we did not foresee or need in the past, but just to ensure that actually, as we transition away from this world that Ben described as being, again, not in harmony with nature as we should be looking towards, but we make sure that this transition takes us to a better place that is really centered on greater harmony with nature, but also, of course, systematic mainstreaming and integration of human rights. I think maybe, unless there is a final comment, yeah, Elisa, perfect.
No, just a reflection. I've been exploring also my collaboration with GANRI, and I've been thinking a lot about the role of national human rights institutions, and there may be reflections that are relevant also for the regional commissions, in addition with the regional tribunals. I mean, one thing we discussed earlier is that really hard place of environmental defenders and also public authorities to some extent engaging with large-scale business enterprises, including foreign investors who benefit from particular protection under international law. And one role, linked to this area that we discussed about how we co-develop solutions and bring knowledge together. In my earlier work, particularly on critical minerals in Argentina, I saw examples where NHRIs are conveners of public consultation processes or EIA processes, which are crucial for the just transition to be respectful of human rights and, in fact, maximize opportunities for the full realization of human rights, and being somehow not only conveners, but also mediators, and being able to point at every point in the conversations and sometimes negotiations where there may be suggestions coming from the business sector that go below the minimum levels of protection of human rights, particularly with regard to indigenous peoples' rights, but of course there are many other aspects where they may also be helping scientists understand the value of their work and the meaning of their work from a human rights perspective, and then how NHRIs themselves will learn from those processes, which can then enrich their activities of advice for legislative processes and any other monitoring. And I think the regional commissions may increasingly play this role, particularly when we see regional trends in either exploitation of, say, transition minerals, regional trends relating to the development of renewables. We have significant evidence of how some, particularly large-scale development of renewables, are not done in harmony with nature. And so we're, again, another paradox of seeking to advance on climate mitigation, but in fact being ineffective from a climate perspective, and also causing harm to nature, to access to water, to cultural rights. So really the aspect of how we support that social interactions, those difficult dialogues that yet are the ones where are inevitable for us to make progress on the just transition, and having actors who can point to both like minimum requirements of human rights as the conversation evolves, and that's the way in which you do kind of capacity, the capacity building of all actors involved on that, but also being able to constructively lead the dialogue towards a place of listening to affected human rights holders, to defenders, and other authorities. So I think that this role in convening and nurturing human rights-based dialogues is really crucial. That's the work that we have once, all the advice is provided, which is emerging every day.
Thank you for this encouragement and reminding us the importance of the institutions that we have with us today. I must say, having followed the negotiations on just transition at the global level for over a decade with some of our close partners in the context of the UN climate negotiation, for sure the discussions there, by definition, they remain quite abstract and conceptual. And so this is very much where institutions at the national or regional level really have a critical role to play, both in helping, accompanying decision makers who sometimes are of goodwill, but just really lack the understanding of what are the methodologies that are used in the context of other challenges and could be replicated in the context of this just transition. And also, of course, of bringing a dimension of accountability again, ensuring that our existing legal norms are duly applied in the context of transitioning away from fossil fuel and, of course, building resilience in the context of a triple planetary crisis. We've heard a lot of recommendations. I will not summarize them just now because we will have another panel continuing to address a similar issue, but I think we had a very rich discussion. I'm hoping that we can continue. In particular, I think some of our discussion really focused on the unique role that regional mechanisms could be playing specifically in the context of the challenges that we discussed. And so I'm hoping that we can continue to foster the exchange of good practices, of lessons learned, of key outputs, whether reports or court decisions, that could actually help inspire other regional bodies, because we've been discussing how governments and governmental stakeholders struggle sometimes with some of these policy-making questions. But of course, it's the same case for many of the institutions that are here with us today, also trying to continue to understand how to play their role to fulfill their mandate in that particular context. And I feel hopefully you can continue to draw inspiration from your own experiences. Thank you so much for all of the experiences shared today and for those who also contributed to the discussion.
Thank you. Sorry for causing disruption at the beginning.
You are not the only one. No, don't worry. We will have started in a few minutes. It was just to know if
it was like close of
To the podium, please. Yes. Now I get a gavel there, so that's very exciting.
Run.
But you don't have a hand. Oh, you do? Sorry.
This is.
She said she would come
Yeah,
right
it's
at the
here.
time, so it's.
She's here in the back.
Okay, good.
Oh, yeah, she's there.
Yeah. Maybe somebody needs to grab her. Yeah.
Hi, Ben.
Hello, how are you? Good, good.
Hey, everyone, how are you?
Thank you. Oh, we're in the same section. Apparently.
now.
Well, you can sound a bit happier about it, Edmund. Yes.
Yes. All good?
Yep.
All right. Okay. Welcome, everybody, to a continuation of our discussion on just transition with some new faces and new perspectives. I'm still here, though. So Ben Schachter, I coordinate the Environment and Climate Change Unit here as the facilitator this time, so I'll try to keep things short. Thank you all. I'm looking forward to hearing from our speakers. We again would invite them to reflect on anything they've heard so far, to share concrete ideas and recommendations about how human rights mechanisms can support the development of the concept of just transition and just transition programs that advance human rights, identify possible areas of collaboration and priorities for action, etc. I think all of us were here for the previous session, so should be ready to jump right into the discussion. The first speaker I'd like to introduce is Javier Plumo Lantes. He's the Special Rapporteur on Economic, Social, Cultural, and Environmental Rights with the Inter-American Commission on Human Rights. Javier, we'd love you to speak to how the Inter-American Commission can engage on issues related to advancing sustainable development pathways, just transition, reducing inequalities and poverty, and potential areas of collaboration with the UN and other relevant mechanisms.
Okay, thank you very much, Chair. I'm gonna speak in Spanish again. I think I am the only one that is speaking Spanish. Yo voy a tratar de ser bastante sintético en relación a este tema, que es un tema muy relevante para la región. Y es un tema que se encuentra en el centro del debate. Creo que un aspecto importante de este debate es tomar conciencia o considerar que enfrentamos un dilema que no es exclusivamente jurídico. En el centro de este debate hay disputas políticas profundas sobre los modelos de desarrollo, sobre todo en América Latina y el Caribe, teniendo en cuenta el rol que le ha tocado y que le toca aún a América Latina y el Caribe en un contexto internacional. Estamos hablando, por lo tanto, del extractivismo. Y estos modelos de desarrollo y estas prácticas extractivistas que no comienzan con la minería de los minerales críticos de la transición energética, sino que son tan largas como el descubrimiento de nuestro continente por parte del colonizador, ponen a prueba la protección ambiental. También está en el centro de este debate la geopolítica de la transición energética, los intereses vinculados a las tecnologías y a la geopolítica de los minerales críticos de la transición energética, sin duda. También está en el centro de este debate los riesgos de la captura del Estado y la captura regulatoria de intereses empresariales. Y la forma en la cual estos intereses empresariales terminan siendo amparados por regímenes jurídicos regulados por tratados bilaterales de protección de inversiones. Por eso es un tema súper complejo, no es un tema exclusivamente. Nosotros nos acercamos con el lente de derechos humanos, pero es un tema que tiene una complejidad política, económica, y en términos de democracia, extremadamente relevante. Desde el punto de vista jurídico y con un enfoque de derechos humanos, el marco interamericano cuenta con estándares bastante interesantes, bastante claros, sobre todo a partir de de la opinión consultiva de la Corte Interamericana de Derechos Humanos y la resolución 321 de la Redesca y la Comisión Interamericana de Derechos Humanos. La opinión consultiva del 2025 sobre emergencia climática y derechos humanos, que como saben reconoce el derecho humano a un clima sano, delimita algunas obligaciones estatales, reducir drásticamente emisiones, regular actores privados que generan daño climático, adaptarse a los impactos para proteger derechos humanos ya amenazados por el calentamiento global, asegurar procesos democráticos inclusivos, respeto a saberes tradicionales, garantizar el derecho a la ciencia, los derechos de acceso a información, participación pública, acceso a la justicia, protección efectiva de personas defensoras del ambiente, medidas diferenciadas para abordar situaciones de grupos en un contexto de especial vulnerabilidad, en una situación de especial vulnerabilidad. Y la resolución del 2021 que les mencioné, la 3/21 de la Relatoría Especial sobre Derechos Económicos, Sociales, Culturales y Ambientales y la Comisión Interamericana de Derechos Humanos, ya se había referido a la obligación de limitar emisiones antropogénicas, regular actividades que las producen, actualizar marcos normativos, contribuciones determinadas a nivel nacional, con enfoque de derecho. Esto no significa que tengamos un marco jurídico completo. La transición justa y equitativa en América Latina y el Caribe, especialmente en América Latina y el Caribe, tiene que asumir múltiples retos que tienen relación con otros aspectos que mencioné al inicio de mi exposición, bajo la premisa principal de no repetir los patrones extractivistas en el contexto de la transición energética. Patrones extractivistas tradicionales que han sido muy eficientes para profundizar desigualdades y conflictos socioambientales. Por eso una transición que apunte a descarbonizar, a diversificar, requiere elementos muy claros vinculados a la justicia social en América Latina y el Caribe. Hablar de una transición justa es hablar de trabajo decente, es hablar de protección social, o debe ser hablar de trabajo decente, de protección social, la nueva economía, energías renovables, restauración de ecosistemas, infraestructura resiliente. Tiene que ir de la mano con la creación de empleo de calidad, respeto de la libertad sindical, la negociación colectiva, protección social para las personas trabajadoras, redes de cuidado. También la Corte Interamericana de Derechos Humanos, en forma muy reciente, aprobó una opinión consultiva específica sobre el derecho al cuidado y el reconocimiento del derecho al cuidado en el sistema interamericano de derechos humanos. Y otras agendas de participación efectiva y consentimiento. El tema de la consulta y consentimiento libre, previo e informado es un tema crítico en la región. El tema de la protección de las personas defensoras, absolutamente relevante en nuestra región, donde en forma periódica personas defensoras del medio ambiente pierden su vida. Entre otros aspectos, la rendición de cuentas, fortalecimiento de las instituciones democráticas, etc. En relación al papel de los mecanismos regionales, y voy a cerrar con esto, hay varias acciones que se tienen que abordar. La primera está vinculada con reforzar acciones de monitoreo de las políticas de transición energética, especialmente vinculadas a los minerales críticos. Recibimos reiteradamente reportes en torno a situaciones complicadas de una perspectiva de la afectación de derechos de personas y comunidades. La segunda es profundizar el desarrollo de estándares interamericanos específicos. La Corte Interamericana nos ha proporcionado, como les dije, algunas obligaciones, pero es necesario especificarlas. Y tercero, desarrollar la competencia de la Comisión Interamericana de Derechos Humanos y la Redesca en términos de promoción y cooperación técnica, de forma de traducir esos estándares en políticas públicas, emitir orientaciones técnicas, acompañar reformas normativas, etc. Como les decía, este es un tema crítico para la región, absolutamente trascendente desde el punto de vista del sistema interamericano de protección de derechos humanos, pero además es un tema central en las agendas de desarrollo de nuestros países. Muchas gracias a todos y a todas, presidente.
Gracias, Javier. So I appreciate in particular the focus on some of the specific actions that can be taken. And I mean, you mentioned the need, one, to avoid a repetition of extractivist patterns and past mistakes, to ensure that the people involved in supporting a sustainable and just transition are protected, the environmental human rights defenders, and then how mechanisms can work to improve monitoring, including of transition policies, to develop standards and support technical assistance and cooperation. And so just making a note of those potential recommendations. And now I would like to invite our next speaker, Edmund Bantaisun from the ASEAN Intergovernmental Commission on Human Rights. He's the current chairperson and representative of Malaysia to the Intergovernmental Commission, and a lawyer with over 28 years of experience in the practice of law at the international and national level. Really the same kind of question to you in terms of what is the role you see for the Intergovernmental Commission in advancing a just transition? Who are the potential partners and ways you can collaborate and work together and take advantage of this forum to reflect on that? Thank you.
Thank you very much. It's a very difficult question, but I think in ASEAN, the role of OHCHR as a regional human rights mechanism encompasses a lot of different ASEAN sectoral bodies across our ASEAN region. So we bring a human rights lens, and I would like to just quickly brief this workshop on how we have been advancing inclusive and sustainable development across ASEAN, while also answering some of the questions at the end of my very short update. So at the start of the year, Malaysia, as Chair, had proposed consolidating two priorities. The two add value rights, the right to development and the right to peace, has been now consolidated into a new single human rights instrument that affirms ASEAN's commitment to inclusive and sustainable development through a human rights-based lens. I'm very pleased to share that our meeting, which just concluded on the 26th of September, we have now finalized a proposed ASEAN Declaration on promoting the right to development and the right to peace towards realizing inclusive and sustainable development. These are two priorities that Malaysia has pursued this year, given the difficult challenges the region in Southeast Asia faces in terms of climate change, environmental degradation, and conflict situations. The proposed declaration establishes and uses the rights to development and peace as the common thread for regional consensus and a unifying language for regional cooperation grounded in our existing instruments and principles. Through this initiative, ASEAN member states share a common purpose across different national contexts and development stages, advancing them through an ASEAN-led, ASEAN-owned whole of ASEAN approach. Importantly, we aim to foster a culture of peace and prevention and to position the peoples of ASEAN as agents and beneficiaries of development rather than passive recipients. Participation, equality, and non-discrimination must also be embedded into development decisions. Anchoring this design in an ASEAN instrument strengthens the normative foundation and bridges our climate, economic, and human rights agendas to accelerate the implementation of the Sustainable Development Goals for people-centered, sustainable, resilient, and prosperous future. To realize the ASEAN 2045 vision that has just been adopted in May, which will guide us for the next 20 years, it is essential to align our green strategic measures with priority SDGs and clearly chart the pathways to reach the goals. Achieving a just and equitable transition will depend on coordinated efforts in several areas: green financing, strengthening climate resilience through protecting livelihoods, food systems, and health with targeted adaptation, social safety nets, early warning systems, advancing energy transition by scaling renewables, enhancing grids and efficiency, and ensuring decent work skills development and affordability while embracing digital transformation. Looking ahead, as an overarching regional commission, we have three different pillars: the political security pillar, social cultural pillar, and the economic pillar. And through our human rights lens, we attempt to mainstream human rights in all these three pillars, and that can be a real challenge in realizing the implementation of the SDGs. However, we hope that the declaration will continue to strengthen regional human rights protection, which includes fostering an environment that enables civil society to actively participate. International and regional human rights mechanisms would serve as vital catalysts and safeguards, becoming most effective when driven by bottom-up approaches. Only by creating space for civil society engagement and emphasizing grassroots involvement can human rights protection systems truly be effective. And that's something that we have been trying to do. We have 30 CSOs with consultative status. Finally, we must not forget to address new generation and emerging challenges such as rapid technological change, misuse of artificial intelligence, environmental degradation, and armed conflict, which necessitate regional collaboration in key areas, including business and human rights, climate action, the protection of those who work to promote and protect human rights, and support for communities in vulnerable situations. Thank you very much. On the partners, we are very keen and we continue to work with the UN, OHCHR at the human rights level at the Commission. We have, as I mentioned, the three different pillars: the ASEAN economic pillar, the ASEAN political security pillar, and the ASEAN social cultural pillar. That kind of architecture has within it government ministries and government agencies that implement the priorities of those different sectors. And for us, that's a challenge in how we can mainstream human rights through these three different pillars of ASEAN. Thank you very much.
Thank you, and really great to hear more about the declaration, looking at the right to development, the right to peace, and advancing sustainable development in a holistic way. I think there's a lot there aligned with what we heard yesterday from Michael from the Committee on Economic, Social, and Cultural Rights with respect to the general comment they have just issued on sustainable development. And there's a lot there that also really, these concepts we're talking about, whether one wants to talk about sustainable development or just transition, they're both centered in human rights, and two, really interlinked, right? You can't have one without the other, and indeed that's how we talk about human rights broadly as well, and I think just important conceptually to recognize. So our next speaker is Ms. Pichman Yofantong, chairperson of the UN Working Group on Business and Human Rights. Pichman is also an associate professor and head of research at the Center for Future Defense and National Security at Deakin University, and leads the Responsible Business Lab and Environmental Justice and Human Rights Project, which are funded by an Australian Research Council fellowship. So Pichman, very glad to have you joining us today, and there's been a number of points raised about business and human rights, and really love to hear your perspective on the role of businesses in advancing a just transition and how that relates to regional mechanisms.
Sure. Thank you very much, Ben, and to colleagues from OHCHR for inviting the UN Working Group on Business and Human Rights to be part of this important conversation today. And I very much look forward to hearing the results of the discussions as well later on. Now, let me just be unequivocal in saying this right at the outset. Businesses have a responsibility to respect human rights, and that includes the right to a clean, healthy, and sustainable environment. This is a recognition that is very much enshrined in the UN Guiding Principles on Business and Human Rights, or UNGPs, which were unanimously endorsed by states in the Human Rights Council more than a decade ago now. And as part of that, businesses are expected to conduct human rights due diligence. And again, this includes assessing the environmental impacts that their operations and business relationships can have on human rights, and including those that pertain to environmental harm and damage. So with that having been set out, hopefully as clearly as I can set them out, I wanted to acknowledge, much in the same way as my other colleagues sitting here have, that this is an issue that clearly demands urgent attention now, because businesses, even though they are widely acknowledged as being key interlocutors, key stakeholders in this drive for renewable energy, or the renewable energy transition, it remains the case that we see a lot of the same patterns persisting in relation to extractive models and in relation to business-related human rights abuses in various parts of the world. And so the transition to renewable energy, as the working group has acknowledged in our report to the UN General Assembly back in 2023 on the extractive sector and just transition, we acknowledge that this transition to renewable energy is essential. But if it were to be continued through the same exploitative logic that we've seen until now, we risk reproducing the very injustices that we seek to end. And we risk reproducing the very same business-related human rights abuses that we seek to prevent. And so it goes without saying that whilst the challenge of the just transition is global in scope, the stakes are especially high in regions of the global south, such as those in the Asia Pacific, Latin America, and the Caribbean, and also in Africa. These regions are simultaneously on the front lines of climate impacts and other environmental impacts, and they are also at the center of the resource and infrastructure projects that are meant to facilitate and fuel the renewable energy transition. But as we see played out time and time again, the pursuit of national security and energy security with that has often resulted in human rights violations, in the lack of consent provided by Indigenous peoples, for instance, for these projects that are taking place on their territories and on their lands. And so the paradox here is a stark one. The very regions most at risk of climate change are also being asked to supply the minerals, the land, and the labor that powers or is meant to power the world's decarbonization effort and to move towards a zero carbon economy. And so again, this is why businesses must play a pivotal role and why we must ensure that businesses are held to account when they do not fulfill their roles and responsibilities as outlined in the guiding principles in relation to respecting human rights. The UNGPs, the guiding principles, are very clear in how businesses, again, have to conduct robust human rights due diligence, not only within their own operations, but equally across their business relationships and value chains. This includes, for instance, mapping, preventing, and addressing actual and potential adverse human rights impacts to at-risk and marginalized rights holders, including Indigenous peoples, frontline communities, and workers, to ensure that free, prior, and informed consent, or consent more generally, is being respected prior to the development of resource extraction projects, for instance. But importantly, aside from the first pillar on the state duty to protect human rights and the second pillar on the business responsibility to respect human rights, the guiding principles are also very clear in relation to how there needs to be access to effective remedies when harms occur. And admittedly, this is the pillar where we see the least progress on, and where we see businesses in particular still continue to struggle to provide effective operational level grievance mechanisms in line of guiding principle 31 to ensure that such mechanisms are not only effective from the perspective of providing timely remedies, but that they are also providing remedies in a way that is consultative with the communities or the individuals who have faced harm. And here I wanted to focus in particular on the experiences of Indigenous peoples. The working group has worked closely with various Indigenous rights organizations, many of which have been working actively on the subject of the just transition. We are also in the process of developing an information note on free, prior, and informed consent that is meant to provide businesses in particular with guidance, but also states, with guidance on how free, prior, and informed consent can be arrived at in a way that respects the rights of Indigenous peoples as enshrined in the UN DRIP. I'm mindful of the time, but let me just share here that for many Indigenous peoples and communities across the world, we hear time and time again how the current renewable energy transition is not fully respectful of their rights, that their knowledge of ecosystems, that the role that they play in conserving biodiversity, amongst many other things, are not sufficiently acknowledged by states and by businesses alike, and how, as a result, their leadership needs to be put at the center in order to ensure not only cultural survival in a number of cases, but that there are co-prosperity models that are put in place to ensure that the business operations are not resulting in human rights harm, but that they are also doing good in that regard. So I know I have just 5 minutes, but let me end on this note about what regional human rights mechanisms all of you in this room could help to do in order to help us as a working group to further advance our mandate to promote, disseminate, and implement the UN guiding principles on business and human rights. The very first is for I would ask for your assistance in really raising awareness about the UN guiding principles in the various jurisdictions that you work within, to reference the guiding principles as standards for just transition frameworks, and to ensure in so doing that human rights are not an afterthought, but in fact serve as a foundation for just transition initiatives. It would also be very helpful to collaborate even further with your mechanisms when it comes to monitoring and reporting on whether just transition programs in fact respect labor rights, Indigenous rights, and other forms of social protections in order to ensure that decent work and social equity are also at the center of the renewable energy shift. And then it would, of course, and this is something we hear all the time from affected rights holders, regional human rights mechanisms, along with national human rights institutions, play an invariably valuable role when it comes to providing platforms to affected communities to participate meaningfully in shaping policies and in terms of providing also access or enhancing access to effective remedies for where harms may occur or where they have already occurred. So here I think, again, the working group is very willing and very happy to collaborate further with the many mechanisms in the room here today to really ensure that there is accountability when it comes to corporate conduct. And this, I must add, includes financial institutions because financial institutions too play a very important role in ensuring that human rights due diligence is being conducted, especially when it comes to financing renewable energy related projects and programming. We would also love to see how we can work more with you on ensuring policy coherence and ensuring that national policies and regional initiatives are aligned with the UNGPs and that national strategies for growth and energy security do not undermine human rights, but in fact enhance them through requiring businesses to conduct human rights due diligence. And this can include mandatory human rights due diligence where that process is embedded in national laws. And then finally, I think it's very important, as my colleagues have noted earlier, for us to be working together, for us to be speaking with one voice in relation to how important it is to prevent the reprisals and retaliation against environmental human rights defenders who are doing extremely legitimate and important work to ensure that the renewable energy transition is in fact a just one. So on that note, let me just end with the recognition again that we have a chance here, an opportunity to really deliver a just transition, one that advances human rights, promotes decent work, reduces poverty, and ensures that both people and planet are being safeguarded in a way that does not that ensures our continued survival as a human species. But I would also say that we need to ensure ultimately that this issue is not treated only as a human rights issue per se, but that it is also embedded into security agendas, that states in particular are holding businesses to account because ultimately, as the UNGPs point out, the state duty to protect human rights is the very first pillar of the guiding principles, and the states have that obligation, to provide a conducive environment for businesses to be rights respecting. So on that note, I think I'll end there, but we just need to ensure that the renewable energy transition, as my colleagues say, is not just a transition, but in fact a just transition. So with that, I'll hand it back over to you, Ben. Thank you.
Thank you very much, Pejman. And before I turn to our final speaker of the panel, I just remind you all to think about questions or comments you want to share with us at the end of these presentations. We'd really look forward to hearing your reflections on what's been shared before or so far. I just want to emphasize as well, the importance of that initial statement that businesses have a responsibility to respect the right to a clean, healthy, and sustainable environment. And I think, that needs to be our starting point in terms of thinking about the approach to a transition and the responsibilities that businesses have in the context of a transition. And you also raised, Pejman, really important issues related to due diligence, some ideas about collaboration on monitoring and reporting, and raising awareness of the GPs and the obligations of states to effectively regulate, as well as the responsibilities of businesses to respect human rights. So Sandra Epal is she's the International Advocacy Director at the International Commission of Jurists. And she's also served as International Advocacy Director and Deputy Executive Director of Franciscans International, where she was directly involved in international standard setting processes related to business and human rights as well as the environment and human rights. We'd love you, Sandra, to share some thoughts from a civil society perspective about what regional human rights mechanisms can do to support the development of the concept of just transition and ensure that just transition programs advance human rights, promote decent work, and reduce inequalities and poverty.
Very ambitious program. So thank you so much for having me on the panel, and that's really an honor to be sharing it with my colleagues from the different mechanisms and the working group. I guess as a representative of the ICJ and an international lawyer, I want to focus on the meaning of human rights law and standards for just transition and policy making in that area. But also I have to recognize that I'm based here and I follow very much the work of the Human Rights Council. So I want to maybe highlight a couple of relevant work that has been done by of things that are happening in that context and that will be important for the work of colleagues from regional mechanisms, but also because everything I will be saying is very much in the perspective of let's continue and strengthen this kind of circulation between these different mechanisms, so international and regional, because this is happening and this is one way of developing international law, this convergence and circulation of standards and development that we are seeing at play all the time, and that is very important because it helps us to make sure that international law remains relevant. And that the law works for people in a given time and that we respond to the current challenges. I'm saying that because oftentimes in this very council that has mandated this workshop, we hear a lot about, questions about universalism or colonialism as like imposing human rights to different contexts. And I think regional and national human rights institutions, but regional mechanisms are also there to help the international level to make sure that we are not missing important realities, but also making sure that we all foster and harness what we share as common humanity, and this is also encapturing universal human rights. So sorry for the digression, but I think it's very important in the times we live right now at the Council, including and within UNAT with mainstreaming human rights across the board. And to me, obviously, just transition, maybe together with loss and damage and reparation is, if you wish, really the core human rights anchorage in the area of climate policies and negotiations, where human rights manifest themselves the most evidently and clearly, because in just transition, there's just, and of course, this is a very qualitative process that we are looking at. So many speakers before me talked about that, but technically, we all know we need to take measures to address climate change in a human rights compliant manner. But we importantly need to prevent future and further harm due to climate change, but also to climate action. So false solutions. And just transition means that these measures will have to take into consideration, obviously, the rights of people, communities and peoples, including their meaningful engagement and participation in designing, implementing and assessing, monitoring these policies and measures. So that was dealt with and highlighted by several speakers before me. Obviously, I have the privilege, but also the challenge of speaking last. So many things have been said already. But I guess one thing that I think Special Rapporteur Elisa on the Special Rapporteur on Climate Change said earlier is that we are talking about a human rights based or perspective or lens. And that's really one of the core elements of my message is this is nothing new. We have been applying a human rights based approach to many policy areas, and just transition is again very much test case or like an area where this is clearly where we need to apply this rights-based approach to very technical policy areas to bring about not only tailor-made solutions that work better, but also cost-effective ones, because we know from other areas that it has worked. So for, let's say, on public health, for instance, we know that it brings better solutions, and that's why I'm insisting. But that's why I was very keen on hearing this initiative by Elisa on local solutions or like innovative solutions from bottom up. I think this is exactly what it is about. Talking about this just transition as being the right-based approach of climate action and economic or development choices that we make for the future is really important because it also has, again, very concrete implications, and I will come to that in a second. But just before that, and because I was asked about definition, I think I very much conceive just transition in everything I say, very much in line with the report that Ben presented on the previous panel, the report from the SG on just transition. It's without undermining the fundamental role of the labor movement and of finding an advancing the just transition agenda. Obviously, I think there are, I want to consider the fuller spectrum of rights that is linked to just transition, as we heard so many times in the previous panel and the previous speakers. So to me, it's also very important to remember that just transition commitments are more and more made by states and more embedded or integrated in laws and policies, including through the NDCs or the long-term low-emission development strategies, among others. And so there is this growing recognition by state that they are bound by obligations and that they are legiferating. I mean, they are regulating this area. And so for lawyers and for all of us here, it's important because if we have this commitment translated into laws and policies, we need to make sure that they are monitored and that states are held accountable for this. And the link between human rights and actionable strategies, national plans, etc., again, is nothing new in the area of human rights and human rights-based approach. So we have a lot of experience, including NGOs have a lot of experience in doing human rights-based monitoring of this and of technical areas. So hence my comment on the last panel as well, that this is maybe very technical, and at times some institutions lack expertise, but it's not completely new in the sense that we are used to engage even as lawyers in very technical areas with the right expertise at hand. Yeah, we talking about again on my path to or on my line with the human rights-based approach to just transition or to transition. I think it's almost a sign of the times that now UNDP and FAO used to use the framework or the Panther framework as they use it, but now it's called Planet. And it's to make sure that, again, it's not inherently or conceptually important to mainstream human rights and to use human rights, because we need to comply with human rights as a principle and as an objective, but it's also giving very instrumental or very concrete tools using human rights principles. So for instance, the Planet framework, it's planning participation, the link to human rights, making the link meaning making sure that policies are aiming at fulfilling human rights and realizing human rights, including just transition policies. Accountability, non-discrimination and equality, empowerment and capacity development, and transparency. And again, this is just a way to say that it is not an academic exercise. It gives really an analytical framework, but that is very actionable and is very concrete. And we saw that again in other areas. So there is no big major challenge to apply it to just transition. And just to give one example of why this is important, and not only conceptually or academically, just taking participation and meaningful engagement. So I think other examples have been given, but I always think of one that has really stayed with me, and it comes from the constituency, and I will close with that, is really from the disability constituency working on climate change. So colleagues from disability groups always give these examples that if you develop certain policies that on the face of them are very good for the environment and to fight against the negative impact of climate change, so for instance, to ban plastic straws to drink, right? This is the good thing to do. This is good for the ocean. This is good for to avoid toxic pollution, pollution, etc. But obviously, when these policies were taken in many different countries, no one had thought of what it means for people who rely on straws to be able to drink. And this is a simple example of why talking to people who are directly affected in different ways and a diversity of people in participation means that we will avoid re-victimizing people or making their lives even more difficult, but also how we will find together solutions that are more effective and actionable. So that's always an example that I like to give because we sometimes don't think about it because many of us don't need these kind of things. And so I think it's always important because it helps us to go beyond tokenism and procedural exercises. I could have said much more on some of the things that I think would be useful to exchange again this circulation of ideas and concrete examples or concrete applications of general standards. But I think Michael probably yesterday talked about the GC27 that was just adopted by the Committee on Economic, Social and Cultural Rights. I think it's very important for regional mechanisms to know and reflect on how this new interpretation is helpful, but we also have a lot of work by relevant special procedures. And very recently, again, we have the special rapporteur now on water who has just published and presented this report on the nexus between energy and water, where you find a lot of useful things on just transition. And I could go on and on this, but of course, I'm sure so many things were presented in the last day, yesterday and today on the more litigation side of things and court decisions, including from regional mechanisms beside advisory opinion, but really also case law, including from the Inter-American Commission on Human Rights and Court of Human Rights. So I'm sure everything was shared. But the two last thing I will leave with all of us is again, yeah, keep integrating the work between regional and international mechanisms because it's our daily bread, including as NGOs. We use that to make sure again that the law responds to the needs and realities of people on the ground. That's what I said at the beginning. But also one very general point, but I think is very important nowadays is we need to all together to ensure that we fight for the respect of the rule of law because the rule of law is currently very much under attack. And I think that everything we are doing, national human rights institutions, courts, commissions, every kind of decisions and things that we put out, if we have an understanding that it's not a problem to ignore and to even prevent this work, then yeah, it will be very difficult to ensure that transition is just. So I think it's a general call to from an ICJ that is an institution that has fought for the rule of law for the last 70 years to not forget this very general point. Thank you.
Thank you very much. And I think it's interesting that the point about needing to go from the regional to the international level, that we haven't really heard much, if anything, spoken to the international processes, the climate negotiations, COP30, where there will be negotiations of just transition work program, the biodiversity negotiations, which we did hear from Armenia about yesterday. But I think there's a tremendous amount of space maybe to speak a little bit more towards some of those connections about how the regional mechanisms can or do engage at the international level, and then of course how they also support action at the national level. And I think looking further at those linkages and hearing from those of you here from some of the mechanisms about some of the ways that you're collaborating either at the international level or to support action at the national level would be wonderful. One of the very first sort of things that happened after the GA adopted Resolution 76/300 on the right to a healthy environment is that there was a reference made to that resolution in the CUP cover decision that followed immediately after, and also just sort of thinking about how do we continue to work and increase consistency across these processes. So I am looking for hands, comments, questions. I know we're at the end of 2 days, but I would really, go right ahead.
Thank you very much, Mr. Chair. Actually, I didn't want to intervene, but I want to thank Sandra for raising the point about the Global South. And these are comments that I don't want to make in terms of what I agree with a lot of the substantive information and the sharing and the normative standards. But I wanted to talk a bit more about processes, and I think this is reflected in some of the views of my colleagues at the Commission. It may not be shared completely by all the commissioners or the previous representatives. And of course, we can have differing views as to how regional mechanisms engage with the UN and the UN engage with us. I think one point is, and this is not a critique of how special rapporteurs or mandate holders approach their work in general as a matter of a blanket statement. Just some observations on my part, but informed by a lot of debates within ASEAN and the Commission. I think there is a sense of feeling among some of our commissioners and representatives in the region that special rapporteurs and the special procedure mandate holders, for some of them who do not come from the Global South, approach human rights normative standards as a given. And when it is shared with commissions like us, it is, the way it's shared rather than the substance. So we can agree a lot on the substance, but the way it's shared and the form that is shared sometimes sounds a little bit too prescriptive. And that for those member states or those representatives that are still trying to grapple with the difficulties, actually pushes back the agenda among some of the more progressive commissioners in the Commission. So I think that there needs to be some nuance in how regional commissions and regional mechanisms outside the global north are approached. Number two, I think we are all realizing also that not everyone around the room or in commissions are exactly human rights experts, but all of us are human rights diplomats. And human rights diplomacy is used as a form of encouragement or persuasion to try and adapt, apply, implement, and accept some of these normative standards. But to sometimes advocate for a one-size-fits-all among regional human rights mechanisms on very contested norms, again, I think pushes back the agenda among commissions that may not be used to the way advocacy is done at the UN and OHCHR. So I just wanted to just quickly flag that observation for the record. And this was actually, some representatives actually mentioned it to me to bring it to the OHCHR since we don't meet that regularly. And I think, again, I want to emphasize it's not so much the substance, but sometimes it's the process. And the process is as important as the substance, especially for a region like ours in Southeast Asia. Thank you very much, Mr. Chair.
Thank you, Edmund. And I think, Pitchman, you wanted to speak?
Well, I was waiting for Edmund to make eye contact with me when he said special rapporteurs and mandate holders. But look, I think it's a valid point, right? That process has to be nuanced, and there is no such thing as a one size fits all. We say the same thing when it comes to the UNGPs, but in respect to the concept of human rights due diligence. Not even though all businesses have the responsibility to respect human rights, not all of them will conduct human rights due diligence in the same way. And that's because it still needs to be a process that's contextualized and that actually takes into account, let's say, the sector and the size of the business, that sector it's operating within, et cetera. But I will say that I think for a lot of special procedures mandate holders, we do try to be very nuanced and attentive to the local situation. And I certainly hope that Edmund, in our engagements, that the work of the working group has been useful to the Commission as well. And we look forward to further collaboration on that point. But it's to say that I think, yes, we need nuance, and at the same time, substantively, we need the solidarity in relation to, you know, that the right to a clean, healthy, and sustainable environment amongst other human rights are really non-negotiable in a substantive sense. But with that, over back to you, Ben.
Thank you. And Sandra, please go ahead.
Unless someone else from the room, because I had the opportunity to speak, but I currently don't see anyone. So, yeah, just to respond. I mean, I stand to what I said. Obviously, I don't want it to be misinterpreted, and I'm happy that you just said we usually don't have issues on substance, but more process, because obviously what I said is nothing about relativism, you know, cultural relativism or regional relativism about a universal rights norm. I was just describing some dynamics that we sometimes hear here. And I really insisted on the fact that obviously everything we do is to make sure that international law still works for people. And obviously sometimes we have treaties that have been adopted, and even environmental law agreements, but mostly on human rights law that date back from the 50s or the 60s, and they were mostly not really explicit on what it means for environment or climate and for the right to a clean, healthy environment. It doesn't mean that this is not something that we need to protect now and here for people to be able to enjoy their human rights. And so in that way, it was more to make sure that human rights are still relevant to the realities of people. And here I do think, again, that regional mechanisms and national mechanisms are key to make this link between the international and the local levels, and this back and forth again. Because Ben, you raised this point in after my presentation of we spoke a lot about one direction, but maybe not so much the other direction, and how regional mechanisms can also contribute to international negotiations, etc. We think is a good way to send it back to the room. Thank you.
Thank you, Sandra. And I am checking the room one last time to see if there's any further comments. And I would also just invite the panelists if they have any final reflections they would like to share. But first, Ana Paula, please go ahead.
I was hesitating, taking the floor now. We are so close to ending, you know, like I think people just want to wrap up. But this topic is too close to my heart, and I found that the discussions and the presentations in both panels are very interesting. I'm happy to see Pichamo here, because if you've seen how much of business has been mentioned throughout all the panels in that discussion. But I think what we are basically dealing is that thinking of the role of courts, of commissions, of the different mechanisms. When you have just transition, basically we are going to be saying, like, states, you're doing very bad things. You are not transitioning fast enough. But then we are also going to see, like, oh, the way that you are doing might be problematic. So it's a very complex in how to measure that, how to weight. Not only on not doing enough fast enough, but also not doing it well. And we also know that doing, when it comes to the lives of people, we know, for example, this race for critical minerals is displacing people, it's causing more pollution. And a lot of that is not even for energy, it's being used for military, it's using for AI and so on. So that understanding is something that I think first I imagine that as it's happening to us, that is going to happen, the same is going to happen to the to regional and sub-regional mechanisms. You're going to be overloaded because if before we were used to that level of like patterns of violation, now the world is changing very fast the way that they are, it's happening. So it's like everybody's on adrenaline or in terms of like seeking answers and making mistakes in that process as well. So I think that comes tidying up with the other panels as well when we talk about the role of environmental human rights defenders, also as knowledge holders, listen to what they say. Indigenous peoples are very much affected in that just transition because it's changing. The same way that climate change is changing their ways of living, that just transition, the way that is not done properly, so let's not call it just transition, but the transition is also harming them. So let's find that space, but also in terms of access to justice, and also access to, so they all complement. But I think perhaps one reflection that would be interesting to see from the panel is more related, like what is the role that regional mechanisms, sub-regional mechanisms, but also mandate holders can have in making sure that we work on prevention. So we are not just working, we are not working as a response to, but working prevention to make sure that the transition actually fulfills the objective that is deemed to achieve, that is climate justice. So yeah, just working more on that idea of prevention tied with just transition. And that's it.
Wonderful. Thank you very much, Anna. One last chance if there are final questions or comments from the audience, and then I'll give our panelists that would like a minute or so to respond to that question from Anna. Okay, who would like to take Javier? Go for it.
Muchas gracias por estas reflexiones y preguntas. Creo que hay, vuelvo a decir, creo que hay algunos temas de fondo que son claves para poder operar con esta realidad específica desde el sistema interamericano de derechos humanos, por lo menos. Uno de esos aspectos es cierto vacío normativo que tienen muchos de los países. Por ejemplo, en los temas de empresas y derechos humanos, tenemos soft law a nivel de Naciones Unidas, tenemos también un informe de la Comisión Interamericana de Derechos Humanos y la Redesca sobre estándares interamericanos de empresas y derechos humanos. Tenemos, no del todo generalizado, pero bastante generalizado, normas programáticas vinculadas a la política pública de empresas y derechos humanos, planes de empresas y derechos humanos. No tenemos leyes de debida diligencia en forma generalizada. Y de hecho, hay algunos países que están procesando discusiones parlamentarias vinculadas a leyes de debida diligencia, pero habría que ser muy optimista para considerar que estaríamos frente a una transformación normativa interna con un impacto relevante. En el ámbito internacional tenemos un debate estancado desde hace ya más de 10 años, vinculadas a un tratado internacional que establezca algunos estándares normativos vinculantes de empresas y derechos humanos. Y en este contexto de vacíos normativos vuelvo a decir, también de actividades que se amparan en tratados de protección de inversiones, bilaterales de protección de inversiones. Nos vemos enfrentados en la práctica a una situación difícil desde la perspectiva de la garantía, la protección de los derechos humanos en el contexto de extractivismo de minerales críticos o grandes obras de infraestructura vinculadas a parques eólicos, o energía solar, etc. Y para colmo, contamos en muchos casos o con una institucionalidad de control, supervisión, monitoreo, que en algunos casos es débil, en otros casos se encuentra de alguna forma desfinanciado, no cuenta con los recursos necesarios para poder realizar los controles. Lo que da cuenta de ciertas debilidades desde el punto de vista del actuar, de la actuación del aparato público, de forma de poder actuar en forma preventiva. Dificultades que son tanto normativas como institucionales. A mí me ha tocado como relator especial tener una reunión con una persona que tiene a su cargo la jefatura de un ministerio de ambiente en uno de nuestros países, que me mencionaba de que si no es a través de apoyo de la cooperación internacional, no tiene los cuadros técnicos para medir la polución del agua de un río. En este contexto es muy difícil pensar en el mundo ideal de la prevención. Y en este contexto es donde se verifica y verificamos en la actuación de monitoreo situaciones críticas vinculadas a violaciones de derechos humanos en el contexto de la transición energética. Los esfuerzos por eso, desde mi punto de vista, tienen que estar vinculados a reforzar marco normativo y reforzar también aparato institucional. En el caso del marco normativo y el derecho internacional, yo ya lo he dicho varias veces, creo que los países de las Américas, de América Latina y el Caribe, deberían comenzar a reflexionar si no sería positivo abrir la discusión sobre un tratado interamericano que aborde algunos otros aspectos vinculados a empresas y derechos humanos. También mencionado la necesidad de fortalecer la institucionalidad estatal vinculada a las políticas ambientales y climáticas, darles la mayor jerarquía posible, dotarlas de recursos técnicos y financieros. Y en el caso de los tratados de protección de inversiones, que de alguna manera limitan la acción de los estados vinculadas a la garantía, protección de los derechos humanos y especialmente el derecho al ambiente sano, también creo que los estados, tal como lo analiza la propia Corte Interamericana de Derechos Humanos en su opinión consultiva sobre emergencia climática y derechos humanos, podrían problematizar esta situación, dando lugar a renegociaciones o denuncias. Creo que hay desafíos normativos muy claros y que no actúan, vuelvo a decir, en el vacío, y voy a lo primero que dije cuando tomé la palabra en este panel. Muchos de nuestros países, los países de la región, no tienen un menú muy grande de estrategias de desarrollo. Su inserción en el sistema económico global está muy vinculado a sus recursos naturales y a la explotación de los mismos desde distintas perspectivas. Por lo tanto, cualquier reflexión que apunte a abordar este tema en forma seria tiene que considerar estos aspectos vinculados a las estrategias de desarrollo de los países, porque son esas estrategias las que van a permitir financiar los servicios públicos de calidad, de educación, de salud, la protección de los derechos de las personas trabajadoras. No quiero extender mucho más, siempre me extiendo mucho. Gracias.
Thank you very much, Javier. If there are any final, very brief comments, we do have to move on. We're a little bit behind schedule to the wrap up. So Sandra, very quick, please.
Quick, no, I think to me what is very important is to say that special procedures at the international level, but also Commission and special rapporteurs like the ones from the Inter-American system are definitely the vector between what I said. The people on the ground and the lived realities and whatever standards we want to develop, and so to make sure that the law is still relevant and works for people. So I think that's where also we learn from people what is best to prevent further harm in terms of and Paula's question in terms of prevention. It's really important as well. So I think that's. Again, if we want human rights to be more than cosmetic or like a very academic exercise, we need to apply them and to make sure that this is done in a real way. We need all of these mechanisms that make sure that we hear human rights defenders, we hear civil society, and we hear people who are directly concerned. So that's an important instrumental value. Thank you.
Thank you. Pitchman.
Did Edmund want to go first?
Did you also? Okay.
Okay.
Pitchman.
All right. Well, thank you. I will quickly say that, firstly, I want to acknowledge that there are regional human rights mechanisms and national human rights institutions in this room, including on the session, who have been helping us to really advance the UN guiding principles on business and human rights and their implementation, and also in relation to the just transition. So thank you very much for all the work that you're doing to support that effort. If there are just two key messages I would like for all of you to go away with after my interventions. The first one is that the UN guiding principles matter, and they do provide a clear and authoritative framework for businesses in relation to how and why they must respect human rights. And the second message is simply this: the conduct of corporate human rights due diligence is a preventative tool. So to Anna Paula's point, if we want to prevent businesses from doing dodgy things, basically on the ground, or to commit human rights abuses, then they should be doing human rights due diligence to detect both actual and potential harms. They need to address them and also mitigate them and remedy them when they occur. So I would say that this is where both states and businesses need to come together to ensure that this is happening. And this can include both through national action plans on business and human rights, but equally through mandatory human rights due diligence laws. So on that point, back to you, Ben. Thank you.
Wonderful. Thank you all. If everybody could join me in a round of applause for our panelists. We will now very quickly transition to the recommendations, which gives me the ability to refrain from trying to recap the summary and invite my colleagues who have been studiously taking notes of all of these insights to come and share a little bit on what they've done in that respect. Thank you.
Was that a pun? As we transition to the I thought, Ben, wow.
Always transitioning.
Upping the pun game.
Thank you, Chair.
There we go.
Oh, brilliant.
Maybe here.
Do we have a printout of the statement just in case?
Everything's.
Can you perhaps share it with me?
Yeah.
Or something?
Oh,
Yeah.
I can read it from my phone.
maybe now.
It doesn't appear for some reason.
Here.
He's here?
Yes.
Yeah. Oh, yeah, he's here.
Please sit on your right.
Where would you like-
Normally,
I can change, swap them.
this is his nameplate? Oh, that's you?
Yeah.
Yeah, you stay here. And yeah, this is here, exactly. Very good. Dear participants, we are proceeding without ado to the last agenda item of our global workshop, Regional Human Rights Mechanisms, which is the wrapping up agenda item about ways forward related to recommendations to strengthen cooperation between the United Nations and regional human rights mechanisms to advance the right to a healthy environment. This agenda item will be basically it will be based on the notes that my colleagues have taken during the 2 days of very fruitful and lively discussions on the previous agenda items. Before my colleagues read some of the recommendations, I would like to highlight that we are not, the purpose of this seminar is actually not to adopt any declaration or an outcome document, but rather come up with recommendations and ideas about enhancing cooperation between the United Nations and regional human rights mechanisms. And these recommendations and ideas will be included in an official document of the United Nations, which will be a report on behalf of the High Commissioner to the next session of the Human Rights Council, which will be held here in March. So the ideas and the recommendations that my colleagues are now going to read out, again, will not be adopted or voted today. Rather, you're going to have some time to add something that is missing, to fill some gaps in what will be read. And then again, all this is going to be reflected in the report of the High Commissioner. Without further ado, I would like to give the floor to my colleague Matthias Klettermeier, Human Rights Officer in the National Institutions and Regional Mechanisms section of the Office of the High Commissioner.
Thank you, Vladan. I will start by just mentioning some of the best practices and recommendations that were mentioned under agenda item 1, which were the first 3 panels yesterday. The theme was taking stock of developments in cooperation between the United Nations and regional human rights organizations since 2022 and identifying areas for enhanced cooperation. So it was clear from the discussions that information sharing goes both ways with the United Nations and international mechanisms informing the work of regional mechanisms, while these regional mechanisms also in turn inform the work of the United Nations. And for some examples, panelists mentioned contributions from United Nations and international mechanisms to regional mechanisms in the context of country visits, reports, thematic dialogues, and joint declarations. Participants also mentioned various instances in which regional mechanisms contributed to international deliberations, including through contributions to the UPR, Universal Periodic Review, to treaty bodies, to reports of special procedure mandate holders, and other various UN events. Some regional courts also mentioned receiving third-party interventions from OHCHR, special procedures, and other mechanisms, and cooperation between regional mechanisms among each other and with the United Nations were strengthened through various MOUs and joint human rights frameworks, which we also heard about. Also, various capacity building initiatives and dialogues between regional courts were mentioned between courts and the United Nations, including mutual visits, trainings for judges, information sharing through online events, and a tripartite judicial dialogue between courts in Africa. We also heard from several regional courts about progress made in expanding transparency and accessibility through various means. We also heard information on efforts to establish an Arab human rights court. This was also provided. Now, coming to some recommendations from these first three panels. These include for mechanisms to maintain regular and strategic dialogue rather than only focusing on ad hoc activities. It was also recommended to enhance collaboration by increasing cross-referencing of work to amplify impact, foster joint efforts to set standards and norms, and ensure that recommendations are better aligned. The importance of continuing cooperation through establishing formal cooperation, such as MOUs, concrete plans for implementation, such as roadmaps, and capacity building with UN partners, but also by institutionalizing senior official meetings was mentioned. The current workshop was noted as a good practice, as were the meetings of focal points of regional human rights mechanisms. The good practice of joint platforms on certain thematic issues was noted. The UN Special Rapporteur on Trafficking in Persons spoke about a recent initiative to enhance coordination among various independent experts working on asylum matters and migrants, namely the Platform of Independent Experts on Refugee Rights, which was launched in December 2023. Panelists also noted the need for cooperation among mechanisms to result in better articulation of global norms and regional norms. Mutual learning and capacity building was highlighted as important. The OHCHR fellowship program for staff members of regional human rights mechanisms was mentioned by several entities as a very useful initiative that should be expanded. And there was also the idea of possibly replicating such a program in regional mechanisms. Now moving to agenda item 2, advancing the right to a clean, healthy, and sustainable environment. These were panels 4 and 5. Participants observed that regional and international human rights mechanisms are increasingly recognizing the right to a clean, healthy, and sustainable environment through resolutions, treaties, declarations, and jurisprudence. A key concern remains the implementation of these standards at the national level, or a lack of such implementation. Participants also flagged several obstacles on the implementation. Science was underlined as essential, particularly in litigation and monitoring, including the knowledge of indigenous peoples. It was noted that social movements and civil society pressure combined with legal action had accelerated the recognition of the right to a clean, healthy, and sustainable environment. And now to some key recommendations made. These include streamlining cooperation on the right to a clean, healthy, and sustainable environment by establishing a platform where regional and international mechanisms can exchange information and practices, including on normative developments on this right, case law, lessons learned in adjudication, and implementation of judicial decisions and challenges. Another recommendation is the need to prioritize the implementation and enforcement of international, regional, and national frameworks on the right to a clean, healthy, and sustainable environment, strengthen the rule of law and compliance mechanisms, including protection of environmental human rights defenders. 3, regional and international human rights mechanisms should continue advancing the interpretation and implementation of the right to a clean, healthy, and sustainable environment. 4, it is essential to address inadequate regulations of business enterprises, including deregulation, by regulating private actors with clear due diligence frameworks, addressing obstacles to access to justice for environmental harm, and ensuring effective remedies. Further, in litigation, participants noted that regional and international human rights mechanisms should harmonize evidentiary standards, including a progressive shift of the burden of proof to states in environmental harm cases or other approaches that are more beneficial to guarantee access to justice for victims. Further, regional and sub-regional mechanisms were urged to address intergenerational equity and justice, and to consider the specific vulnerabilities of children and other people disproportionately affected by environmental harm, including as a result of intersectional factors such as gender, socioeconomic situations, and disability. Further, participants emphasized the importance of regional and international mechanisms to enhance and expand their cooperation in promoting the right to a clean, healthy, and sustainable environment. According to their mandates, this could be done through monitoring mandates, capacity building, contribution to advisory opinions, engagement in environmental multilateral processes, etc. Further, regional and sub-regional mechanisms can support further clarification of the content of the international duty to cooperate and also document lessons learned about positive and negative impacts on human rights of international cooperation efforts relevant to the right to a clean, healthy, and sustainable environment, with attention to SIDS, LDCs, and LLDCs. And lastly, there's also a need to further clarify scope and content of the extraterritorial obligations of the states when it comes to environmental harms. And as mentioned, these are just this is just an overview. These will be elaborated on in the report that Vlada mentioned. Thank you.
Thanks, Matthias. A few other points will be added by our consultant, Faiza Sidi, in the next couple of minutes or maximum 5 minutes. Faiza, you have the floor.
Thank you, Vladlen. I'll provide a summary of the discussions under agenda item 3, 4, and 5. On agenda item 3, the discussions focused on the role of regional human rights mechanisms in contributing to accountability and remedy for environmental harms. And in the discussions, what came out clearly was that there's a lot of public interest litigation on environmental harms taking place on several themes. Due to limited time, I'll just share the key recommendations. The first recommendation that came out is that to all mechanisms, there's need to review the key findings contained in the cases and advisory opinions and consider their relevance to updating legal standards and practices of each mechanisms. The second key recommendation that came out from the discussions was a need to expand and enhance cooperation amongst regional and international human rights mechanisms, either through a working group or an annual platform, where these mechanisms could share their experiences regarding the protection of the right to a healthy environment. And lastly, there was a need to explore how regional and international human rights mechanisms can hold corporations or businesses directly responsible for environmental harms. On agenda item 4, the discussions focused on advancing the rights to participation and access to information in environmental matters and the situation of environmental human rights defenders. And the key highlights of the discussions focused on the importance of access to information and participation in the protection of the right to a clean, healthy, and sustainable environment. Many stressed the crucial role of HRDs in this area, especially in providing evidence, leadership, and vision on the progress we need to see on environmental protections. However, there's serious and growing concern that was raised about attacks faced by HRDs and the global and regional trends in this regard. In terms of the key recommendations, there's need for regional and international mechanisms to explore collective protection strategies to safeguard environmental human rights defenders without endangering the individual HRDs. Secondly, also coming up from this discussion was a proposed platform where all these mechanisms could exchange information on how to support human rights defenders, as well as the access to information and public participation. Another recommendation coming up is that there's need to support regional mechanisms in applying intersectional approaches to secure the right to information, participation, and access to justice for all environmental human rights defenders. Also, there's need to encourage regional and international mechanisms to ensure that their processes are accessible to frontline defenders. Lastly, that there's need for regional and international mechanisms to encourage states to adopt anti-SLAPP legislation to protect HRDs from frivolous legal claims. Mm-hmm. On agenda item 5, which was the last panel. Sorry, give me a minute. On agenda item 5, on just transitions, these were the key issues that emerged. One, there is need to build the capacity of all stakeholders and human rights institutions in taking into account a wide range of knowledge in the context of policy processes relating to just transitions. Secondly, there is need for sharing of cases and decisions that illustrate methods of integration of knowledge in human rights application. There is also need to map and exchange novel approaches to foster community-led and intergenerational approaches to the promotion of a just transition. Also shared was there's need of sharing experiences across regional and national human rights bodies with regard to both the civil and political dimensions, as well as the economic and social dimensions of just transitions. Thank you very much.
Many thanks, Faiza. Is there anything extremely important that has been missing and you would like to see reflected in the report of the High Commissioner? Any ideas or anything? If not, and mindful of the time, I would like to give the floor now to Abdulaziz Tioe, the Deputy Director of Global Operations Division in the Office of the United Nations High Commissioner for Human Rights.
Thank you, Vladen. I would say good afternoon or good late evening, good late afternoon for all of you. To all of you, and on behalf of OHCHR, I would like to say thank you all for taking the time to be here and for the constructive discussions. I mean, the distinguished delegates, the experts, and also colleagues that really make this workshop happen. If one message is clear, it is that cooperation between international, regional, and sub-regional mechanisms is more essential than ever. Only by working together can our response match the scale and complexity of the human rights challenges before us. As mentioned by many over the past 2 days, the pushback we are facing on human rights requires us to have a unified voice at all levels, including national, regional, and international. The case in point is the triple planetary crisis, I should say, climate change, biodiversity, loss, and pollution, whose scale, speed, and cross-border impact necessitate collective action. Of course, cooperation is central. It has been mentioned by colleagues in the recommendations. Is particularly central to the reforms carried out by the United Nations in the context of the 80th anniversary. As OHCHR expands its regional presence and engagement, we will work more directly with regional human rights mechanisms. We also note that many regional human rights mechanisms are promoting environmental rights, each in unique and context-specific ways. It is encouraging to see how everyone is tackling the issue. Our hope now is that these efforts can be coordinated in more strategic way. Strategic and regular cooperation between UN mechanism and regional and sub-regional mechanism will be crucial for aligning approaches, bridging gaps, and accelerating progress towards the right to clean, healthy, and sustainable environment. This can also strengthen the impact our efforts will have with regards to preventing harm, regulating private actors, and ensuring access to remedies for rights violations. We appreciate your feedback on the ongoing cooperation initiatives with OHCHR, including the fellowship program for staff of regional human rights mechanism. We welcome the positive feedback we have received on its practical value and the need to expand the opportunity for more participants. In closing, I would like to say thank you to the permanent mission of Belgium for its leadership on the Human Rights Council resolution that made this workshop possible, and also the unwavering support lent to OHCHR. We are grateful to all panelists, moderators, and participants for your engagement. I would like also to express my appreciation to the Geneva Environmental Network, hosted by the United Nations Environmental Programme, for streaming the workshop online. I now declare the workshop closed and wish you safe travel back home. Thank you.